Garda, Marcos, Osmeña, Pangilinan, Pimentel, Recto, Revilla, Soto, Trillanes, Villar, the Senate President.
With 23 senator judges present, the presiding officer declares the presence of a quorum. The majority floor leader.
Mr. President, may I ask the Sergeant-at-Arms to make the proclamation?
The Sergeant-at-Arms is directed to make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority floor leader.
Mr. President, I move that we dispense with the reading of the May 8, 2012 Journal of the Senate. It's sitting as an impeachment court and consider the same as approved.
Is there any objection? The chair hears none. The May 8, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will please call the case before the Senate sitting as an impeachment court.
Case number 0022011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances, Majority Floor Leader.
Yes, Mr. President, may we ask the parties for their respective appearances?
Good afternoon, Mr. President. On the part of the House Prosecution Panel, same appearance. We are ready, Your Honor.
Noted. Defense.
Good afternoon, Your Honor. For the defense, the same appearance, Your Honor. We are ready, Your Honor.
Noted.
Mr. President.
Majority Floor Leader.
Mr. President, we have received a letter from the Ombudsman, Conchita Carpio Morales, requesting that she be allowed to testify ahead of all other witnesses during today's hearing in view of heavy volume of work and equally urgent professional work that needs her immediate attention. So I move, Mr. President, that this matter be submitted to the presiding officer.
What's the pleasure of the defense?
If Your Honor, please, we wanted to accommodate the request, Your Honor, but we assure the Honorable Ombudsman that we will call her today, only that we be permitted to call ahead of her other witnesses whom we have subpoenaed for today's hearing, Your Honor.
But Walden Bello is not here.
We have Noli Emmanuel Santos, Your Honor.
But whatever these witnesses will say in this court will still be dependent upon the findings of the Ombudsman, if indeed she conducted an investigation of the complaint of these witnesses that were subpoenaed, who were complainants before that office. So why not hear the Ombudsman first? And if there's a need to ask the other witnesses to corroborate her, then so be it.
Okay, then subject to the discretion. We yield to the discretion of the Honorable Court,
I
Your
would
Honor.
suggest that we hear the Ombudsman first, because if there's no need to present these other witnesses, if the Ombudsman has made a substantial presentation or no presentation at all, then even if we do not hear these witnesses, this court will already given an opportunity to see the tendency of the evidence being presented today.
Okay,
yes.
then, Your Honor, we submit to the discretion of the court.
Then,
we made known our option, but if it does not meet the conformity of the court, we submit, Your Honor.
Well, we felt, I felt, this chair feels that given the fact that we are calling one of the highest functionaries of the government, she's no less than the Ombudsman, with power to investigate cases in the entire government, from top to bottom. Then I think we should hear first if indeed there is any evidence at all that is available from her against the respondent. So let the order of presentation start with the Ombudsman.
Mr. President.
Yes.
Yes, before we proceed, Earlier today also, we received a letter from Ms. Risa Hontiveros Barakel requesting clarification as to the purpose and expected content of the testimony she is directed to provide, considering that she has not made any allegation or reference to foreign-denominated accounts amounting to $10 million belonging to Chief Justice Corona in her letter request to the Ombudsman or in any other form. May I move that the presiding officer also rule on the request?
Well, while we respect the position of the subpoenaed witness, Madam Barakel, the court is not in a position to determine what the defense will be asking from her. That depends upon the defense. So I don't think it is proper for us to control the defense in this respect. Under the rules of evidence, a witness, when called, has a duty to answer questions propounded by the producing party if she or he takes the witness stand. So the request is hereby not granted.
And finally, Mr. President, one more item. This is,
floor leader.
just for the information of the court and the parties, we are in receipt of an email from Representative Walden Bello informing the court that he is currently abroad on official travel to attend and lecture in conferences as authorized by Speaker Feliciano Belmonte Jr. Representative Bello is requesting that his presence in the impeachment trial be deferred until after his return to the country on May 18. We take note of the
I
letter,
don't
Mr.
think
President.
we have any control over that matter, so we will wait for his return to appear before this court.
Yes, Mr. President, Senator Drilon agrees.
If there's any need for him to testify, then we will require him to appear here when he comes back. So ordered.
So may we now call on the defense, Mr. President, for the continuation of the presentation of evidence.
In compliance with the statement made by the Honorable Presiding Judge, Your Honor, may we call the Ombudsman to the stand?
The Honorable Ombudsman, is she around already? Yes. Please bring her in and swear her. One minute recess to wait for the Ombudsman.
Honorable Ombudsman Conchita Carpio Morales. Session is
The session is resumed.
Honorable Ombudsman Conchita Carpio Morales, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth in this impeachment proceeding?
Yes, I do.
So help you God.
Thank you.
Thank you. Counsel, proceed.
Mr. Presiding Officer, please.
Yes, what's the pleasure of the prosecution?
On the part of the prosecution, Mr. President, may we ask permission that our lead private lawyer be recognized, be allowed to receive the testimony of the Ombudsman and to conduct the cross if necessary. Attorney Mario Bautista, Your Honor.
The request of the prosecution is granted.
Thank you.
The counsel referred to may now take the podium and take care of the case for the prosecution.
Thank you, Mr. President.
Proceed.
With the kind permission of the Honorable Court, will you kindly state your name and other personal circumstances for the record, Madam Ombudsman?
Conchita Carpio Morales, 71 years old, 70 years old, going 72. No, I'm just kidding you. I'm 70, I'm going 71. I am the present Ombudsman. What else?
Your residence, please.
Residence number 9, Carpio Compound, Soldiers Hills, Muntinlupa. Married.
May we be allowed to proceed, Your Honor?
You have the floor. You can proceed, Counsel.
Yes, Your Honor. Madam Ombudsman is being presented, Your Honor, first to prove that he has an interest against Chief Justice Corona, the respondent in this case, to show that the Honorable Ombudsman is currently conducting an investigation against Chief Justice Corona, especially with respect to his alleged foreign-dominated bank accounts in the aggregate value of $10 million, to prove further that there is no evidence or basis whatsoever for the imputation that C.J. Corona has foreign-denominated bank accounts in the aggregate amount of $10 million, and to prove that the Honorable Ombudsman investigation is illegal, baseless, and not in accordance with the Constitution.
In other words, you are considering this witness as a hostile witness?
Right, Your Honor.
Then comply with Section 12 of Rule 132.
Well, the fact that the witness, Your Honor, had made statements both in the TV and the radio, castigating or commenting on the propriety of the Ombudsman, or on the propriety of the Chief Justice, Your Honor, to continue.
Counsel, wait. I'm not trying to hurry you up, but whatever was said outside this court is not evidence. I will read to you the rule. A witness may be considered as unwilling or hostile only if so declared by the court upon adequate showing of his or her adverse interest and justified reluctance to testify, or his or her having misled the party into calling him as or her to the witness stand. So please comply with that requirement.
There are two kinds in our humble submission, Your Honor, of hostile witnesses. First is one who is introduced right from the beginning, is a hostile interest because of the interest he has in connection with the subject matter of the complaint, together with the person of the respondent. And secondly, a witness who had been presented as an ordinary witness, but who turned hostile in the course of the proceedings, in which case we may ask for a ruling on the part of the court that he is a hostile witness in view of the statements made by him.
My understanding of the rules of evidence are the classes of witnesses: willing witness, unwilling witness, hostile witness, adverse with party as a witness. So, can you cite to me the rule that you're using to justify in considering the Ombudsman immediately as a hostile witness? Is not an adverse party to this case.
Yes, Your Honor, but
The presumption is the party producing a witness is producing the witness as a friendly witness.
well, that is our impression also, Your Honor, but a deeper analysis of the situation involved in hostile witnesses showed two different occasions whereby a witness may be considered hostile.
But precisely Section 12 requires you to lay the basis. Qualify your witness in the way that you want that witness to be treated on the witness stand, and let the court make the ruling.
Very well, Your Honor. We will proceed as directed, Your Honor.
So proceed.
Now, your Madam Witness, you are familiar with the De Castro case before the Supreme Court in connection with the qualification of the Honorable Chief Justice Corona.
Yes, Your Honor.
And that involves the validity of his appointment as Chief Justice of the Supreme Court.
Yes, Your Honor.
And I understand from the records of the case that you were the lone dissenter
That's
insofar as the validity of the appointment is concerned.
That's right, Your Honor.
It is your contention then at that time that the Supreme Court has no authority, much less any power, to rule that the former or outgoing President of the Republic of the Philippines may appoint a Chief Justice to the position after a declaration, 2 days after the election, Your Honor.
Yes, Your Honor.
In a motion for reconsideration, you likewise sustained your stand as objecting to the qualification of, no, rather, not the qualification, but the power of the President to appoint the Chief Justice, Your Honor. All right.
Yes, Your Honor.
In that motion for reconsideration, you cling to the view that GMA, or the Honorable ex-President Macapagal, has no authority, Arroyo has no authority to make the appointment, Your Honor.
Yes, Your Honor. I always clung to my earlier decision if I thought that my decision for the first time was correct.
But knowing that the Supreme Court acts as a collegiate court, the majority did not sustain you, am I right?
Yes, Your Honor. And that is...
And the majority opinion declares that the President, in this particular case, can appoint, even notwithstanding the holding of an election and a determination that the winner of a winner in that election.
Yes, Your Honor.
And it is a time-honored practice that what governs the resolution of the issues involved in a case is the majority opinion.
That's right, Your Honor.
All right. So there is no further question as to the validity of the appointment, of the appointing power belonging to President Gloria Macapagal Arroyo.
You're asking me?
Yes.
Well, that's the decision of the majority of the Supreme Court. So we have to abide by the decision
That's correct.
of the majority.
That's correct. And you will agree with me that there is no power on earth that can modify, reverse, or much less set aside that decision of the Supreme Court.
The members who wrote the majority can always change their mind, Your Honor.
Yes, but that is not my question to you.
Yes,
Madam
there's no
Ombudsman.
power, you
Correct.
said, on earth who can reverse or change the decision of the Supreme Court. And
That's
I said the power emanates from those who want to change their mind.
Because judicial power belongs only to the Supreme Court.
That is a fact, Your Honor.
Okay. Now, notwithstanding that pronouncement made by the Supreme Court at the time, the President do not appear to be comfortable in accepting that kind of an official action.
Which President?
Your Honor,
The
please.
present President.
I am not competent to answer that, Your Honor.
Yes, but you must have read in the papers, together with speeches over the radio and the television, or you are not aware of that.
I read them, but whether or not that is true, sometimes, you know, reports get into the papers, but they are not exactly accurate.
Mr. President, may I raise an objection, please? Counsel for the prosecution.
What is the basis of the objection?
The defense counsel has been requested by the chair to qualify the witness as a hostile witness so that the chair in turn may declare the witness as such. The mere fact that the witness was the sole dissenter in the De Castro case does not qualify her as a hostile witness. As the chair correctly ruled, a hostile witness is one who is, number one, an adverse party, number two, an adverse party witness, number three, someone who is reluctant or does not want to testify, and number four, someone who is established to have an adverse interest to the accused.
I'm sorry, Your Honor.
All of those situations
I'm sorry.
are not present, so that it is premature for the counsel of the defense to start impeaching the witness before she has been qualified as a hostile witness?
Well,
I'm just starting.
I have to sustain the objection, counsel. The first rule is a party producing a witness is not allowed to impeach his own witness. So objection sustained.
I'm not, if Your Honor, please, I'm not impeaching the witness. I'm laying the basis to show hostility and attitude on the part of the witness that qualifies her to be a hostile witness, Your Honor.
Then reform the questions. So, please.
All right. Now, I am not asking you about the truth of what the President Aquino have stated, that he does not like the Honorable Justice Corona to be occupying the Chief Justice of the Supreme Court. But I'm asking you, my question to you is limited to the fact whether you are acquainted with those news spread over the TV,
Yes,
the radio.
I have read those news.
All right. And according, you also must have heard the fact that there was a statement by the Honorable President Aquino now that he is not willing to take his oath of office as a president before the Honorable Chief Justice.
That's right, Your Honor.
And as in fact, he made mention of the fact that he would rather take his oath before a barrio captain.
That's right, Your Honor.
If Your Honor, please, these questions are irrelevant to the adverse interest of the witness. They have nothing to do at all with the qualification of the witness as a hostile witness.
Qualifying the witness, Your Honor, is not borne out by one and only question, Your Honor.
Let the Ombudsman, who is a very intelligent witness, answer the question.
Thank you, Your Honor. Pakibasa na yun.
Yes, he said that early on he said he wanted to take his oath before a barangay captain. That's the question.
Yes, and there was also statements made by him that he will try his level best not to allow the Chief Justice Corona to continue occupying the position to which he was illegally appointed.
That I don't know.
You have not read it in the papers?
I could not recall reading that.
You do not recall also having heard it over the radio?
I seldom listen to the radio.
Counsel, may I suggest that you go direct to the point. Find out direct questions regarding the hostility of the witness towards the respondent. She's the Ombudsman. She's investigating the respondent.
Okay then. Thank you, Your Honor. Now, in fact, he took his oath before the Honorable Ombudsman now.
That's a fact, Your Honor.
Yes. And that notwithstanding, Chief Justice Corona attended the oath-taking, is it
That's
not?
right, Your Honor. I
He was
witnessed
there.
him.
He was there.
Yes.
All right. Now, in the course of a certain event, like the Criminal Justice Summit, Your Honor, you must have read over the papers also, as reported, that there were statements made by the President against the Chief Justice.
Your Honor, please, may I object again? May I raise a continuing objection to this line of questioning? I do not see the point in establishing any hostility there may be between the President and the Chief Justice. We have the witness here as the Ombudsman.
Yes.
What's the connection between the Ombudsman and the President?
Well, at that time, Your Honor, we wanted to show how hostile the President was, and having acted that way led to the filing of this complaint for impeachment, Your
That's
Honor.
totally irrelevant, Your Honor.
We submit, Your Honor.
No.
We are only in the process of...
Let the witness answer. We will be very liberal.
Yes, Your
And
Honor.
let's see the defense.
I think I
what
was
they're
abroad
doing.
at the time. But eventually, I was told about it.
Now, I noticed that in your... Before, I am aware of the fact that before your appointment as Ombudsman,
Ombudsman.
yes, Your Honor, there is a necessity that nomination be made by the Judicial and Bar Council.
That's right, Your Honor.
And you are aware of the proceedings in that body.
I just knew about it through others because I was not present.
And you came to know that one of those who did not vote for your nomination is the Chief Justice.
I eventually came to know when they invited my attention to the internet data showing the results of the voting.
The Chief Justice is not one among those who voted for your nomination.
Yes, that's
He
right.
was opposed to your nomination. Is that?
Whether he
Did I
was
understand
opposed to my nomination, I do not know. But it's a fact that he did not vote for me.
May I intervene, Counsel? I would like to be very liberal, but may I request you to go direct to the point by showing the adverse interest of the witness with respect to your client, the respondent. What's the adverse interest of the witness such that if that is established, then she will be considered as a hostile witness?
I'll go into that direction, Your Honor, but I was trying to deal with it little by little.
Yes,
in the hope that
I do not want to control you, but I think, why don't you ask her if she's the one she has investigated the case of the respondent.
Okay, thank you, Your Honor. Now, may I go to a letter dated April 20, 2012, purportedly addressed to one Renato C. Corona, Chief Justice, Supreme Court, Manila, consisting of 5 pages, and direct your attention to a signature appearing over the typewritten name Conchita Carpio Morales, Ombudsman.
I would suggest that the counsel will show that letter
Yes, Your Honor.
to the witness. so
Which
that,
we request, Your Honor, to be marked as exhibit. With witness examining the same, Your Honor.
This appears to be a photocopy of my letter.
May I request first, for purposes of identification, Your Honor, that it be marked, as we prayed before, as Exhibit 253. Consisting of 5 pages. A little earlier, I was asking you to go over the signature appearing over the typewritten name Conchita Carpio Morales, Ombudsman. That is your signature.
Yes, Your Honor. That is so.
Now, there are 3 complaints involved in this investigation.
Counsel, why don't you ask the Ombudsman why she wrote that letter to the respondent?
Yes, Your Honor. Now, I adapt the question. Will you kindly tell us why this letter was written or addressed to the Honorable Chief Justice Corona?
Yes, Your Honor. After we received the complaint from, it's difficult to memorize the first mentioned complainant, but one of them is Liza Ontiveros. I went over it because I had an advance copy, and I first sought information from agencies, and then I referred the complaints to the Anti-Money Laundering Council because I thought that the charges included of some matters that was what were within the jurisdiction of the AMLAC, and then later I constituted a panel of investigators, and eventually I wrote the AMLAC seeking assistance towards the determination of the truth of the charges, and then I got an initial report from the special panel recommending, among other things, that we should write the Chief Justice.
Now, in this letter, you are asking the Chief Justice to explain in writing
That's right, Your Honor.
his, and may read the particular portion, Your Honor. Accordingly, consistent with the provisions of Section 15, 22, and 26, you are hereby requested within 72 hours from receipt hereof a written answer to the complaints and to the above stated information respecting your alleged several bank accounts in several banks.
Yes, Your Honor.
All right. Now, I understand that in this kind of investigation by your office, the respondent is akin to an accused in a criminal case.
Your Honor, please. The questions are leading. Up to now, the witness has not been qualified nor established, declared by the court as a hostile witness.
Well, that's a direct question, Your Honor.
Counsel, why don't you reform your question? Ask the Ombudsman if by that letter she was actually investigating the Chief Justice.
Because I predicate the
That would be the adverse interest.
Okay then, Your Honor. Now, when you stated in this letter that the Chief Justice is being requested to submit within 72 hours from receipt a written answer to the complaint, my understanding is that she is already being investigated by your office. Am I right?
We were doing a case build-up. In other words, it was a fact-finding investigation, Your Honor.
All the while, I thought that the complaint per your letter is on the basis, this letter rather, is on the basis of the three complaints. One, by the group of Roberto Alrosa, second by Walden Bellio, and the third one by Emmanuel T. Santos.
Yes,
Right.
we were.
I'm sorry. Go ahead.
Whenever we receive a complaint, we determine first if it merits docketing. So we docketed it for purposes of factual investigation or case build-up.
All right. When you ask him to file an answer,
Yes.
the answer that you wanted to be made by him is in connection with the allegation of this strictly confidential resolution.
Your Honor, may I invite your attention to the second to the last paragraph